AB 5 is a new law that goes into effect on January 1, 2020 that outlaws most categories of independent contracting in California. So if you're a business that employs individuals in California, or you're a business that enters into service contracts with individuals in California, you need to understand to comply with this new law. One of the things that people really misunderstand about California's new independent contractor law is that it does not apply to just the gig economy. In fact, it applies to all categories of workers. There's certain professionals such as lawyers, doctors, dentists, architects, and the like are exempt. There are other professional employer exemptions. One of the questions that we're asked frequently is, well, geez, the IRS has its own independent contractor test. What applies? Is it the new California law, AB 5, or is it federal law? And the answer is, it's the California law. So while federal law, generally speaking, does trump state law in most circumstances, in this instance, it's the state law, which is the law that would protect most workers, would apply. What if both parties agree that I can be an independent contractor? Well, you can't. Effective January 1, 2020, the state law is very clear that the parties, even if they're in agreement, cannot agree to violate the law. There are tests that can be applied. It's very important to consult legal counsel, if possible, to determine whether or not one of those exemptions would apply, or whether or not the individual fulfills each of the requirements in order to be deemed to be an independent contractor under California law, because those restrictions are now very rigorous.